the national human rights institutions worldwide are established as a result of international obligation of countries. It is not the same with other institutions because it's an international obligation of Nigeria. Resolution 48-134 of 28 December 1993 enjoined all nations of the world to establish national human rights institutions for the promotion and protection of human rights. So it is sui generis. It's in a climate of its own. So when we start comparing it with other national institutions, we get the point wrong. As for the purpose for which this public hearing was called today, was intended mainly at 3 or 4 provisions. The other provisions of the law had been settled because in 2010, this National Assembly thought it wise to make the National Human Rights Commission a truly independent commission, a commission that could bite, a commission that will really rise to defend the poor people of this country, just like distinguished Senator Desin said, individuals who cannot confront the organs of state, who are so weak that they don't have the capacity. That is what we are looking at. Without even looking at other ones, this issue of compensation. I'm aware of the Court of Appeal decision, which has been appealed on, so it's not yet a final decision. Actually, it was upturned at the Court of Appeal and is going again up to the Supreme Court now, where the issue where violation of rights of the people of Niger Delta in terms of environmental degradation, the Commission sought to hold public hearing to hold those oil companies accountable for the violation of environmental rights and award compensation and damages for the citizens of this country. And the court at first instance said that the Commission could not exercise its rights. And we went on appeal, and the situation now is, there's no gainsaying that the Commission has a mandate and it has to exercise it, no matter who it brushes against. Now, this amendment is meant to harmonize the provisions of the 1995 Act and the 2010 Act. Since the gallant amendment of 2010, we have been operating 2 laws, the 1995 Act and the 2010 Act. At times, stakeholders make mistakes. They refer to one of the laws, ignoring the other one. So it's like the situation of the law is not clear at any point in time. So it makes sense that the National Assembly now will repeal the other ones and make one law so that anybody looking at the provisions of National Human Rights Commission will only have one legislation. So we are fully in support of that move by this National Assembly. The other one is the issue of the Human Rights Fund, which was equally introduced by the National Assembly in its wisdom in 2010. You can agree with me. Look at surprises like the NSAS protest. There was no, as I'm telling you now, the Special Investigation Panel, which the Human Rights Commission instituted to deal with NSAS protests, has not yet been funded up to now. Now, could we have made provision for the NSAS protest in the budget of that year? Human rights, look at the security situation in the country. These things are rising every day. If government of Nigeria really wants us to be effective, the issue of this Human Rights Fund should not even be negotiable, because, you know, all the companies were asking to make contributions. Are they not supposed to benefit from a peaceful climate to conduct their business and make profit? It cannot be government alone that should fund a peaceful environment, which human rights adjudication, determination of violations will help this country. A lot of the problems we're having in insecurity are as a result of human rights violations that have not been attended to in the past, as exemplified in the NSAS protest. So, human rights commissions, looking at these complaints by Nigerians, resolving them quietly without, raising any noise, is contributing to the peace we have in the country. And if the commission is not supported in terms of such a fund by all the beneficiaries and is left to government alone, it is not going to be possible for government to fund, maintenance of peace and order. So that is why it is thought necessary that all benefactors that are enjoying from the peaceful climate to do and prosper in business should also make some little contribution to the Human Rights Fund. And that will augment the provision which the government is already making in the national budget. The third point which this bill is looking at is the issue of effectiveness in terms of the day-to-day functions of the Commission. The Commission has a governing council which should at least meet once a month. Now, the functions of dealing with complaints of human rights violation, the council has appointed staff that investigate these complaints on a daily basis. There may be need to invite a complainant or an alleged violator to come and explain certain things. We deal with mediation, conciliation, alternative dispute resolution. You must summon people to come and, to afford both parties fair hearing. It is such a fundamental tool of our work under the Constitution that we must hear both sides. How can you tell a complainant or an alleged violator to come to the office if you cannot summon him and he is bound to come to answer you? Otherwise, you don't be a toothless bulldog. So anybody who makes a complaint, you call the alleged violator, he says, go to hell, I'm not going to go. What do you do from there? Or do you have to go to court first and get an order of court for the person to come and answer? We get almost 1 million complaints in a year, for goodness sake. How can you, in every case of a complainant, you have to go to court, to go and get an order of court, to allow somebody to come and answer to allegations before the commission? That will kill the commission. That will make sure that the commission does not function at all. So that is why it is very, very necessary that these powers to invite people to come and answer to complaints of human rights violation should lie with the day-to-day operators of the commission. The chairman is a part-time chairman. He attends meetings and goes away. So if a complaint is made and the executive secretary cannot summon somebody or invite somebody to come and explain, it weakens the operations of the commission. Now, the other one is the provision which the National Assembly had, ingeniously also made to empower the commission, which means that decisions of the commission can be registered as decisions of the High Court and made enforceable. This was because earlier on, if the commission made any decision, people could flout it and say to hell with the commission. So in the wisdom of the National Assembly, and this is in line with the Paris principles, which is what happens in other national human rights institutions, that decision can be registered as a decision of the court and made enforceable. Now, we are saying that in order to make it simpler, because in effect, what means that the decision of the commission can be given to the registrar, and the registrar can use the Service and Civil Process Act to enforce it. And that will make the decision of the commission very, very effective. So what happens now, at times we do mediation, we do an MOU, and parties can decide to be bound by it, or they can decide to violate it. So in that way, this provision will make the decisions of the commission more effective and more useful to Nigerians. And, and it's also, that once something is like a decision of, that means you can appeal on it. It's not as if it's a final decision. And then let us also go to the issue of determination of compensation and damages.
Sorry.
Yes.
Can we go back to the issue of the registration of the findings?
Section 22. Section 22 of the proposed act.
Recognition and enforcement of awards.
Yes. Says that the decisions of the commission can be registered in the court and made enforceable as decisions of the High Court. Now, we are saying that this can even...
When you say can be made enforceable,
and will be made...
What process are you going to make?
Exactly. That's what we want to clarify better, because this is a little bit... So what we are proposing in my recommendation is that we're recommending that an award or decision made by the Commission may be delivered to the Registrar of the High Court, which order the Registrar is empowered and required to receive and register without payment of a fee, and when so delivered, the order shall have effect as a judgment of the High Court and may be enforced accordingly. So we think a simple process like that, will be straightforward and not confusing. So if you have a decision like a complainant or an alleged violator, if you have a decision from the Commission, you can proceed to the Registrar of the High Court and deliver it to him, and the Registrar shall enroll that order and activate the Sheriff and Civil Processes Act. And this is also what happens in the Tribunal of Inquiry Act. It's a simple process like that. And coming to the issue of award of damages and compensation, the Constitution in Section 36 does not anticipate that it is only the court that will look at human rights violations. From the clear provisions of the Constitution, there are other bodies who can also listen to human rights violations. Like it says, that provision says, in the determination of his civil rights and obligations, including any question or determination or against any government or authority, a person shall be entitled to a fair hearing within a reasonable time by a court or other tribunal established by law and constituted in such a manner to secure its independence and impartiality. Tribunal there it does not require, refers to other bodies which can have quasi-judicial function. The clear point there is that they will be independent and impartial. And the Commission is already an independent institution by grace of this National Assembly. And the impartiality of the Commission is assured by the fair hearing process. All our processes are fair hearing. And in assessing these damages and compensation, the important thing is that the parties are given an opportunity, like that section of the 36 go for that to say, without prejudice to the foregoing provisions of this section, a law shall not be invalidated by reason only that it confers on any government or authority power to determine questions arising in the administration of a law that affects or may affect civil rights and obligations of any person, provided such law provides an opportunity for the person whose rights and obligations may be affected to make representations to the administering authority before that authority makes a decision affecting that person. So what we're saying here is that it is not a monopoly of the courts to listen to human rights complaints. It's not a monopoly. The Constitution also anticipates that in addition to the courts, other tribunals or other bodies can listen to human rights complaints. And that the most important thing is that that body is independent and impartial. And that in its processes, it affords whoever party is involved a fair opportunity to be heard. And this is in line with the complaint treatment mechanism of the Commission, which ensures fair hearing, which ensures impartiality, and which ensures independence of the Commission. And like has been said, the Commission will be rendered to a toothless bulldog if it cannot assist victims of human rights violation, if it cannot determine the question of whether somebody's right has been violated or not, if the Commission cannot look at a deserving situation and say, this person whose right has been violated is entitled to compensation. And under the Constitution too, the Constitution is very clear that if any person's right has been violated, that person shall be entitled to compensation, an apology, a rescission, and so on and so forth. So it is very, very important and useful that the Commission should be able to assist victims of human rights violation by, in appropriate cases, giving them compensation. This compensation we're talking about can even be the medical expenses on which, for instance, you beat a woman to stop her and you take it to hospital. She brings medical bills that she has spent at 6,000 naira. Are you saying the Commission cannot say, look, this person who has caused this violation, refund this woman at 6,000 naira? That is what we are talking about. Are we saying that somebody who has been violated, and maybe he has to be, look at the NHRC something. We are talking of people whose legs have been amputated because they received gunshot wounds. The commission determines, yes, your right has been violated because of this. And you cannot calculate the cost of medical treatment. Medical treatment in a government hospital, the cost is known. This commission is being proposed not to be able to say, this person who has caused this human rights violation that has led this amputation, the cost of this medical treatment is 2 million naira, you have to pay it. I think if we arrive at that decision, it will destroy the entire essence of having the commission. And I believe that this honorable National Assembly, this distinguished National Assembly is used to doing justice to all manner of the people. The human rights is not for the rich, it's also for the poor, and everybody should be able to go to the commission. Assessing the costs in this country, everybody knows how difficult it is. You have to have money. You have to be able to go on for 2 or 3 or 4 years. And how many people are ready? The act of the commission says, if somebody comes to you, for instance, and you determine that the right thing for him to do is to go and sue for him in court, the commission will give him a lawyer to go and sue in court. That is what the commission is meant to be. So it is not going to be looked upon like any other organization. The commission can sue government for violating the right of an individual. But the commission is established by government. It's conflicting, but that is the nature of the mandate. Every other government body who sues the government, it will be a big wahala. But the commission on daily basis challenges the action of government once it is something that affronts the rights of the downtrodden. So our functions and powers must be seen from that angle. If we make this say that the commission cannot compensate victims of human rights violations, it must only be the court, that is the end of human. In fact, it will give human rights violators a blank check to go ahead and do anything they like. That will be the consequence. And I don't think this National Assembly will ever, concur to that kind of situation, because this National Assembly has been known to make law for the good governance of Nigeria, to make law for the oppressed, to make sure that every citizen has an avenue where he can go and his rights can be protected.
Thank you, yes, we appreciate that, but you are spoken for 20 minutes, so you have 1 minute more.
So I want to... the final point I want to make is in respect of the interpretation clause, because in the Act, references have been made to award, recommendation, decision, and determination. I propose that in the interpretation clause, there should be a provision which says that they are all the same, and the reference to determination or decision or award and compensation shall be the same thing, so that there will be no confusion about it. So I want to thank the Joint Committee for giving us this opportunity to come and clarify on our law, and we shall continue to be there if there are any more clarifications that are needed from us. I have not been able to respond to